Okay, we now proceed to the forms of contracts, Articles 1356 to 1358 of the new Civil Code. So 1356, contracts shall be obligatory in whatever form they may have been entered into, provided all the essential requisites for their validity are present. However, when the law requires that a contract be in some form, in order that it may be valid or enforceable, or that a contract be proved in a certain way, that requirement is absolute and indispensable. In such cases, the right of the party stated in the following article cannot be exercised. Okay, class. As a general rule, there is no need for a specific form, but there must still be some manifestation of consent. So, makikita natin dyan, class, na oral contracts are valid. Okay? So, mali yung sinasabi ng iba na kailangan in writing. Bakit mas favored ang in writing? Ayun yung tamang term. Mas favored ang in writing. For evidentiary purposes yun, class. Ha? So, as a general rule, there's no need for a specific form of the contracts, but there must still be some manifestation of consent. Exception, when the written form is required. Okay? So, form of a contract refers to the manner in which a contract is executed or manifested. So, general provisions on forms of contract. The contract may be oral, first, in writing. So, pwede sa public instrument. What do you mean by public instrument? Notarized. Private instrument. To be a written contract, all its terms must be in writing, of course. Partly oral and partly in writing. Valid din yan. A contract, partly in writing and partly oral is in legal effect an oral contract. A contract need not be contained in a single writing. A contract may be encompassed in several instruments, even though every instrument is not signed by the parties, as long as there is consent. Number 4, a written agreement of which there are 2 copies, one signed by each of the parties, is binding on both to the same extent as though there had been only one copy of the agreement and both had signed. So, balikan natin yung pinag-aralan natin before. A consensual contract, a contract, as a general rule, is perfected by mere consent. Diba? So, kahit anong forms yan, oral, writing, partly oral, partly in writing, okay lang yan. Diba? It is valid. Except kung nire-require for its validity yung form yan. Okay? So, ano ba yung examples ng contracts na nagre-require ng written form for its validity? Diba? Donations, antichrists, interest in a loan, sale of land by an agent, contribution of immovables in a partnership. 2 aspects of contracts. Alam naman natin yan. Intent or will. This is internal and as long as a contract exists, merely as a psychological fact, it produces no legal effect because the law cannot take cognizance of its existence. Expression of such intent or will. Okay, dyan papasok yung form. So, informal or common contract, that which may be entered into in whatever form, provided all the essential requisites for their validity are present. Class, wag yung guluhin yung sarili ninyo. Kahit na may in writing ang isang sinasabing contract, pero kulang ng essential requisites, it is not a contract. Di ba? Kasi kailangan may essential requisites. So, class, as long as nagkaroon ng meeting of the minds as to the object and to the cause, there is a contract. Diba? So, perfected yung contract na yon. Except kung nagre-require siya ng form, ng ibang forms. Like, for a formal contract, it requires a form. For real contracts, it requires delivery for its perfection. So, for formal or solemn contract, that which is required by law for its efficacy to be in certain specified form. So, ilan lang naman yan, class. That's an exception. Kasi ang general rule ay kahit anong form, as long as may concurrence of the essential elements, okay tayo doon. Valid yun. Exception, formal contracts. Okay, rules and forms of contracts. So, ayan nga. Contracts are binding and therefore enforceable reciprocally by the contracting parties, whatever may be the form in which the contract has been entered into, provided all the three essential requisites, di ba? Consent, object, and cause for their validity are present. Exceptions, paulit-ulit lang yan, class, ha? A, when the law requires that a contract be in some form. B, when the law requires that a contract be in some form to be enforceable or proved in a certain way. You correlate that, class, doon sa group, yung sa group na magre-report about unenforceable contracts. Please take note, di ba? Statute of Frauds. When the law requires that a contract be in some form for the convenience of the parties or for the purpose of affecting third persons. Okay? So, ayan. Diba? Donation of real property, kailangan public instrument. Kapag hindi public instrument, it is void. Donation of personal property, the value of which exceeds 5,000 pesos. Donation and acceptance must be in writing. Sale of land through an agent, authority of agent must be in writing. SPA. Contract of antiques in writing. Stipulation to pay interest in writing. Pinag-aralan natin yan sa payment class, ha? If the provision pertaining to interest of a loan is not in writing, it is void. Contract of partnership where immovables are contributed, public instrument dapat. Okay? And it shall be attached to a signed inventory of the immovable property. Transfer of sale of large cattle, it must be registered. Diba? So, kapag registered siya, class, it must be in public instrument and a certificate of transfer secured. Negotiable instruments, di ba? Common sense. In writing, walang negotiable instrument na oral. Di ba? So, ma-discuss nyo yung lahat ng negotiable instruments sa negotiable instruments law ninyo. Okay? In cases of contracts covered by the statute of frauds, the law requires that they be in writing, subscribed by the party charged or by his agent. If the contract is not in writing, the contract is valid. Assuming, di ba, all the essential elements are present. But, upon the objection of a party, it cannot be proved, and therefore, it cannot be enforced unless it is ratified. Okay? So, it is a valid contract. Di ba? Valid contract. Nandun yung may concurrence. Di ba? May meeting of the minds as to the object and to the cause. However, it is unenforceable. Di ba? So, paano siya mararatify? I-discuss sa inyo ng group na magre-report about unenforceable contracts. So, cases tayo, Lausok versus Sabay-Sabay. Basahin nyo na lang yung facts. Whether or not the oral contract between them is unenforceable. So, doon sa facts niyan, class, balik tayo. Doon sa facts niyan, class, ang object of the contract is the giving of separation pay. Okay? So, parang nung ibibigay na yung separation pay, ayaw na niya. Ayaw na ni Lausok. Sabi niya, it is an unenforceable contract. Dahil hindi raw nag-comply sa statute of frauds. Ano ang ruling ng Supreme Court? No. It is not unenforceable. Diba? In this case, reducing into writing the oral contract between Lausok and Sabay-Sabay et al. Is a matter of convenience alone, and does not make the contract unenforceable because there was already a perfected contract to give their separation pay. So, perfected na yung contract, class. Okay? And, doon sa contract nila, hindi siya pumasok dun sa contracts which require a special form. Okay? Balik tayo doon, ha? Hindi rin siya pumasok, class, dun sa contracts na kailangan in writing to be enforceable. Okay? So, you have to correlate that to, you have to study the statute of frauds. Unenforceable contracts. Article 1357, if the law requires a document or other special form, as in the acts and contracts enumerated in the following article, the contracting parties may compel each other to observe that form. Once the contract has been perfected, the right may be exercised simultaneously with the action upon the contract. Okay, tatandaan nyo muna, di ba? Before a party may be compelled to execute the required form, it must be valid and enforceable. Dalawa dapat yan. Ha? Kailangan dalawa. Hindi po pwedeng valid na siya because unenforceable naman siya or not valid at all. Diba? So, there's no right to compel kapag ganun ang nangyari. Maliwanag? Gallardo versus IAC. Whether or not the private document of deed of sale is binding and valid. Okay. No. Ano ba yung sabi sa Art 1357? Diba? If the law requires a document or other special form, as in the acts and contracts enumerated in the following article, the contracting parties may compel each other to observe that form once the contract has been perfected. In this case, class, sa Gallardo versus IAC, ano siya, balik tayo sa facts para at least i-ano natin. No? Plaintiffs have applied for the reconstitution of title, but the respondents objected with an affidavit of adverse claim. Gallardo insisted that she is the registered owner of the lot, evidence with a private document. Class, bakit hindi binding and valid yung private document deed of sale? Kasi class, kapag nagpapa-register tayo ng property, it must be a public instrument, public document. Okay? So, pakibasa na lang yan, ha? Yung class, ano yan? So, ito class, forms of contracts. Ano yung kailangan mag-appear sa public instrument? Diba? Acts and contracts which have for their object the creation, transmission, modification, or extinguishment of real rights over immovable property, sales of real property, or of an interest therein. I-correlate nyo yun dun sa kaninang case, class, ha? The cession, repudiation, or renunciation of hereditary rights, or of those of the conjugal partnership of gains. Kailangan public instrument. The power to administer property or any other power which has for its object an act appearing of or which should appear in a public document or should prejudice a third person. The cession of action or rights proceeding from an act appearing in a public document. All other contracts where the amount involved exceeds 500 pesos must appear in writing, even a private one. But sales of goods, chattels, or things in action are governed by Article 1403, number 2, and 1405. Class, dun sa sales of goods, chattels, or things in action, requirement yan ay public document. Okay? So, you have to remember the contracts covered by Article 1358 are valid and enforceable, though not embodied in public document or instrument or in writing. Diba? The public document is required only for the convenience and greater protection of the parties, and registration is needed only to make the contract effective as against third persons. Formal requirements are therefore for the benefit of third parties for the purpose of informing as well as binding them. Non-compliance therewith does not adversely affect the validity of the contract nor the contractual rights and obligations of the parties thereunder. Class, ha? Iba ang validity sa convenience. Okay? So class, doon sa 1358, we have to, you have to remember that contracts, di ba, relativity of contracts, it only affects the parties, successors in interest, etc. One principle of contracts. You have to remember that the third parties, the third persons, di ba, hindi sila privy sa inyong contract. However, class, if your document will be notarized, will be converted into a public instrument, it will be binding to the whole world. Di ba? So, for convenience, kailangan ninyo ng kailangan ninyong i-notarize or gawing public document in order for your contract to protect the parties as well as the third persons. Diba? For the benefit of third parties, for the purpose of informing them as well as binding them. Napag-aralan na ninyo ito before, yung mga klase, yung mga estudyante ko sa persons. Public document is a constructive notice to the whole world. Okay? So, the reduction to writing in a public or private document required by the law with respect to certain contract is not an essential requisite of their existence, but is simply a coercive power granted to the contracted parties by which they can reciprocally compel the observance of these formal requisites. Okay? Maliwanag tayo dyan, ha? Okay, ano ba yung probative value of public documents? The effect of the notarization of a private document is to convert the said document into a public one and render it admissible in evidence in court without further proof of its authenticity and due execution. Sa evidence yung mapag-aaralan yan, class, ha? Okay, public documents are entitled to full faith and credit on their face in the absence of any clear and convincing evidence, more than merely preponderant, that their execution was tainted by defects or irregularities that would warrant a declaration of nullity. So, kumbaga class, para mas mas maintindihan nyo, mas malakas, mas matimbang ang mga notarized documents. Okay? They enjoy the presumption of validity and regularity. It is that, however, the intention nor the function of the notary public to validate and make binding an instrument never in the first place intended to have any binding legal effect upon the parties thereto. Okay. Class, ang notary public, di ba, ina-acknowledge niya na itong si A and B ay nag-enter ng contract of sale. Ngayon, class, paano kapag wala talagang contract of sale? Si notary public ba ay liable? The answer is no. Kasi, hindi naman niya trabaho na tignan kung saan yung lupa na yan, saan, ano yung binibenta, etc. Kailan magiging liable si notary public? Kapag hindi talaga nanumpa on his or her presence yung affiance. Doon pwede kayong ma-disbar. Okay? Marami ng Supreme Court decisions, marami ng cases na dinisbar ang isang abogado dahil sa kanyang notary public. Dahil nagdonotaryo siya kahit na yung mga affiance ay patay na. Kahit naman hindi sa kanya talaga, kahit na yung affiance ay nasa ibang bansa. Yan. Maraming mga nadidisbar dyan. Kaya, kayong mga future lawyers, take note. Diba? Huwag kayong mabulag sa 150 pesos na affidavit of loss. Diba? O 150 pa ba ngayon yan? Or yung mga contract of sale, nababayaran kayo ng mga 10,000 pesos huwag kayong mabulag dahil yung lisensya ninyo ang nakataya dyan. Okay? So, tapos na tayo sa reformation of contracts.